بسم الله الرحمن الرحيم. السلام عليكم ورحمة الله وبركاته. Distinguished participant, I would like to welcome you all to this forum on behalf of the Ministry of Energy and Infrastructure and Transport Regulatory Sector, Department of Maritime Transport Affairs, the Maritime Administration of United Arab Emirates. Also, I would like to welcome and thanks Fitchi co-legal firm for their efforts in cooperation to organize this virtual session, the second webinar in United Arab Emirates Federal Maritime Administration webinar series. It's about the implementation and enforcement of two important IMO instruments, which is the Bunker Convention 2001 and the Limitation of Liability Maritime Claim Protocol 1996. The United Arab Federal Maritime Authority, represented by the Ministry of Energy and Infrastructure, is doing its utmost efforts to enhance cooperation among all stakeholders in maritime industry to furnish the best legal and technical frameworks to provide shipping and trade with the opportunity to create dialogue with key decision makers representing legal and technical maritime partners in United Arab maritime industry. This event comes in line with the vision and strategy of the Ministry of Energy and Infrastructure plans to ratify important IMO conventions and instruments. The Maritime Administration in United Arab Emirates is aiming that this event will achieve its objectives in raising awareness and disseminating the provisions of the conventions and the protocol to all owners of United Arab Emirates flag commercial ships and captains of foreign flag visiting United Arab Emirates ports. Also for the judicial and legal authorities in both public and private sectors in United Arab Emirates maritime transport. As we know that the convention and the protocol unify international requirements and legal standards regarding liability regime for bunker spills and limitation of maritime claims. We hope that this forum will clarify ship owners' responsibility in general and identify ceiling for their responsibility for maritime claims for damages and losses that may arises from maritime accident committed by their ships towards others, including collision accidents with other ships, identify types of protection and guarantees that the rights of all involved parties in the maritime industry. We are looking that this forum will highlight the main challenges as well as key opportunities to enhance confidence in United Arab Emirates maritime industry and strengthen the tools to promote investment in maritime transport and encourage ship owners to own commercial ships and increase United Arab Emirates national fleet to enhance trade and increase the tools of economic security in cargo and commodity flow to and from United Arab Emirates. In this regard, I would like to introduce the main speakers in this webinar, His Excellency Captain Abdullah Al-Hayas, Director of Maritime Transport Affairs, and Ms. Jasmine Fitchi, the Managing Partners of Fitchi Legal. And also Ms. Ifra, she will tackle the question and answer session. And now I would like to invite Captain Abdullah to start his introductory remarks and some important information about the two conventions and the convention and the protocol. Captain Abdullah, the floor is to you.
Yeah, good morning and thank you for joining us today at this webinar. Thank you, Mu'in, for your introduction. I'm Captain Abdullah Al-Hayas, the Director of Maritime Transport Affairs Department at the Ministry of Energy and Infrastructure, which is considered the Federal Maritime Authority in the UAE. First of all, I would like to take this opportunity being with you today to send my congratulations to everyone on the upcoming of holy month of Ramadan, which is coming next week, inshallah. Wishing you and your family happy and blessed Ramadan. As well, I would like to thank the legal firm Fish & Co for their participation with us today in this webinar. I'm thanking them for their continuous support and participation in the maritime events in the UAE. Whenever we call them, they are always showing their cooperation and participation. So thank you, Jasmine, and your team. Before I start the webinar, it is good to shed light on the latest updates from the Federal Maritime Authority. As you are aware, the last few months there was government restructure. The Maritime Administration, or the Federal Maritime Authority, which is used to be under the umbrella of the FTA, has now moved under the umbrella of Ministry of Energy and Infrastructure. There is nothing more called FTA. It does not exist anymore. The Federal Maritime Administration now is under the umbrella of the Ministry of Energy and Infrastructure. Our roles and responsibilities still the same. Nothing has changed. Our headquarters now has changed to be in Dubai, in the Sheikh Zayed housing program on the third floor. And we are looking forward to continue our journey and cooperations with our stakeholder for the benefit of the UAE. So although there was some change in the government structure, but the Maritime Administration is still there, and we'll be happy to welcome you once the COVID-19 is over, to come and visit us as you used to do previously. Today's webinar is one of our efforts at the Maritime Administration in the UAE to keep in touch with our stakeholders. And we will keep having such meetings from time to time to update you about the latest progress made by us at the Maritime Administration, and with the technology available and the intensive use of the technology during COVID-19, which is an advantage. I think there will be more opportunities to have such webinars in the future. And before I start, I would like to pass the mic to my colleague, Ms. Jasmine from Fish & Co. to greet you. The mic with you now, Jasmine.
Thank you very much, Captain Abdullah. Good morning to everybody. I can see the number of attendees. I cannot see who is attending. I hope it's many of our clients and friends. Missing the direct interaction with everybody, but this is how it is at the moment. We can't help it. I assume that the majority of you knows us and knows me. We are Fish & Co., a dedicated maritime law firm in the region. We are working extensively with the FTA. I have to learn, and I will need a few weeks to say FMA, Captain Abdullah. It will take some time to get it out. Now the Federal Maritime Authority. The Federal Maritime Authority has saved lives, especially in recent years with the COVID situation. Most of you will know we had huge problems literally all over the world with stranded seafarers not being allowed to leave the vessels, even if the FMA is going out of the way to make it possible for the seafarers to disembark. They do not want, because they haven't been paid. So on that point, I have to say a big thank you to Captain Abdullah and his amazing team to really try their best to help seafarers, help us, and literally saving lives in a number of cases. So as you see, I'm very dedicated on the maritime side, mainly marine insurance. I think why the FMA has asked us to join today on this joint webinar. I used to work in Hamburg, you can guess it from my German accent, and in London. I'm dual qualified, and in both countries I've worked in law firms who were instructed by the respective government, so either the German government or the English government, assisting mainly in wreck removal cases. And on that count, we were on the receiving end of establishing limitation funds. So I think I might be the only lawyer, one of the very few lawyers in this area who has 25 years back experience with the limitation funds and the LLMC and how it works. I think so much to me. Anybody who has any more questions, just contact me directly. You will find, if you don't find my email address in this presentation, you will find me easily in the internet. I pass back to Captain Abdullah.
Yeah, thank you, Jasmine. If we can move to the first slide, please. Mu'in, you would like to shed light on the convention ratified by the United Arab Emirates before we start talking about the two new conventions?
Yes, Captain Abdullah. Actually, for till this moment, we have the United Arab Emirates ratified 32 convention and protocol coming from IMO as an international instrument to regulate all activities in maritime industry worldwide. The first one is I will not mention all of them, but the most important is about the convention establishing the IMO itself, which is IMO 48, and it was ratified by the Federal Decree number 10, 1981. So this is the first one. There is another important like SOLAS, MARBLE, Load Line, Tonnage Convention, IMO MARBLE 46 Annex 6 also. It's about air pollution control or prevention. The other issues about salvage convention, about the search and rescue, about IMSO, which is International Maritime Satellite Organization. Also about some amendment to this. Also, the most important is about the IOPC fund and the CLC convention, which is about civil liability convention, about the oil pollution, about also the most important one, which is the LLMC 67, which is one of the basic documents that we are going to discuss today, and its amendment by the protocol LLMC 96. Or salvage, we talk about salvage, about ballast water management. It's an environmental also convention. There's a protocol 88 about the load line, which is in harmonized survey, was in line with the SOLAS 88. FAL convention, which is about the facilitation of maritime traffic, very important. This is done in 1965. It's old convention, but it's very important, and there is a major amendments having to this convention. We're coming to the protocol now, LLMC protocol 1996. So this is in general around 31 maritime convention and protocol ratified by United Arab Emirates. So next slide, please. Yes, Captain Abdullah, you would like to talk about that?
Yeah, okay. So the webinar is to shed light on the two important conventions we have acceded recently. The one will enter force next month, and the other has been at the stage of depositing the instruments, so it can be deposited at the IMO at any time, and it will enter into force 3 months after depositing the instrument. So if we start with the first convention or the protocol which we have ratified, the LLMC 1976, which is the Convention on Limitation of Liability for Maritime Claims. The UAE has ratified the LLMC 1976 or 1997. Recently, as you heard in the news, the UAE has deposited the instrument of accession of Protocol 1996 to the convention. So the protocol will enter into force in the UAE next month on 23rd of May. The 1996 protocol will enter into force in the UAE. And before we start explaining the amendment made on the 1996 protocol and how it differs from the LLMC 1976, I think it is important, first of all, to explain what's the meaning of limited liability in the maritime industry and why it is there in the first place. Because we received a lot of questions regarding people they are aware about MARPOL, about SOLAS, but when it's coming to the LLMC, there was a lot of question raised. What is limited liability and what's the need for it? The limited liability concept is a very old concept. Some claim it can be traced back to the Roman or Middle Age. But the concept clearly has spread on the 16th to 17th century in the European maritime nations. So it is not a new concept. The limited liability in the maritime industry is not a new concept. So long time ago, before the creation of the airplanes or the development of the road trucks as we can see them now, shipping was established as the only or the main means of international trade. The sea, as you know, is a power enemy in the past for ships. Claims lives, claim ships, claim cargoes. The reason for that, that in the past they don't have modern weather forecast or navigation tools. So the ships were under the mercy of the weather condition. In addition, they were under the risk of collision or even pirate attacks. So the concern was that the carrier or the ship owner would be liable for any losses which were suffered by the cargo under his care. So the issue here, as in many cases, that the cargo carried on board had a much higher value than the vessel itself. The cargo is value is more higher than the ship. So the owner whose only capital was the vessel itself did not have enough asset. Did not have enough asset to satisfy all the claims which will arise after he lost his ships. For example, there will be a lot of claims against him when both ships and cargo lost at sea. So this unlimited liability could have also led to his bankruptcy at the end. So the question which was raised at that time, the old time, was raised quickly. Would the ship owner have to go down with the ship in such accidents or claims? So if you lost the ship, that's it. The ship owner should announce his bankruptcy and exit the industry. As you can see, that will disencourage people from entering this field of doing maritime businesses. So to meet the potential implication of such disaster of losing the ship or the cargo, the maritime community adopted a system of distribution of losses. So we have the concept of general average, for example, in the maritime industry. We have the marine insurance, and we have the limited liability concept. So in this concept, in the maritime limited liability, the purpose is to encourage the ship owners to continue with their business and to develop shipping in general. Hence, the ship owner is entitled to limit his liability for maritime claims up to the maximum sum, regardless of the actual amount claimed. So the ship owners and certain other connected with the operation of the ship, the operator or the charter, can enjoy the privilege of limiting their liability. And hence, because the liability is limited and known, the ship owner can deposit with the appropriate court, for example, the full amount he may be liable for, and therefore he is free of further liability or legal actions such as the the rest of his ships. And therefore, he's free. He can operate his ship, and he can continue trading, leaving the claimants and the courts managing the limitation fund to arrange for the distribution of the claim. So this is briefly is the concept of the limited liability. If we go to the next slide, so we can see that the Convention of Limitation of Liability for Maritime Claims of 1976 has entered into force in 1986, and the contracting state right now are 55, and world tonnage, the countries which ratify the convention, they represent a world tonnage of 58%. So how the modern age started with this concept, how we end up with the LLMC 1976. If we are saying it is an old regime. After the sinking of Titanic in 1912, as I remember, many claims has been made on this accident. So there was a claims of losing life, personal injury, as well as claim for loss of property. Cases has been brought into courts in UK, in Norway, in United States. So the cases had led to many different judgments. Every court is looking to their jurisdiction, and they came up with different judgments, different from each other. And it was up to their jurisdiction. So the Titanic was, we can call it a wake-up call to the international maritime community on the importance of having a harmonized international law on maritime, on the limited liability for the maritime industry. So we end up after the Titanic having the 1924 Convention on Maritime Limited Liability. The 1924 Convention didn't get that much support, so there was another attempt in 1957 Convention to set a new limit for liability. So they started in 1957. However, shortly, as we entered the 1960 and there was the boom in the industry, in the maritime industry, they discovered that the inflation has increased, the ship size has increased as well. So they end up on revising the 1957 Convention to tackle the issues of increase of ship size and the issue of the inflation. So we end up with the 1976 Convention, which came into force, as we mentioned, as it is showing now in the presentation, 1986. After a while, it has been found the limit of liability prescribed in the LLMC 1976 again has been eroded by the inflation, and we are no longer adequate to satisfy possible claims. So to address this issue, the protocol of 1996 has been adopted. And this is what we have acceded right now. If we go to the next page on the presentation. So what is the new or the main amendment on the 1996 protocol to the convention? The main amendment is that the limit has increased throughout the tonnage level. So the limit of claims has increased, as well as the overall limit for passenger claim is removed, and the limit of liability per passenger is increased. So these are the we can say that the main amendment made in the 1996 protocol. However, as you can see from the slides, there was important change in the protocol 1996 in the Article 8 of the protocol. So the change was made that to update the limit in the future, the protocol provide what we call it the tacit acceptance, which is a procedure, which means that we don't need to come with a new convention. No, it is a process where the amendment which has been adopted shall be, if there is a call to increase the limit, the new limit shall be deemed to have been accepted at the period of 18 months after the date of notification to all contracting states, and shall enter into force 18 months after its acceptance. So there is a procedure now on tacit acceptance in 1996 protocol. So we are talking about a total of 36 months for any amendment can be made. Any amendment based on the tacit acceptance and the limitation of the protocol, it will depend on three factors, which is the inflation rate, the change in the monetary amount, as well as the experience of the incidents, as well as the effect of the proposed amendment on the insurance cost. So with the tacit acceptance, a new limit can be set, and this is what has happened in 2012, where the IMO has announced a new limit, which has entered into force in 2015, based on the tacit acceptance. So there is no need now to change the convention or to amend the conventions. That with the tacit acceptance, the amount of liability can be increased based on the inflation, based on the incidents experience, and based on the insurance cost, as we can see from the next slide as well. This is the new limits which has been set, and this is the calculation is based on the gross tonnage of the ship. The next slide can give us a good pictures of the change made after the introduction of the protocol and 2012 amendment. If we go to the next slide, Mu'in. Yeah, here you can see the development of limitation amount. So we took an example of a vessel, which is, say, the size of 50,000 gross tonnage as an example. And we can see the limitation amount, how it is climbed up, how it is increased from 1957 to 1976 convention to the 1996 protocol, and with the new limit which has been introduced based on the tacit acceptance in 2015. So this is a new mechanism added in the 1996 protocol. There will be a revision from time to time to the limitation amount, which will be in favor for all the states which has ratified or acceded the protocol. I pass the mic now to Jasmine for the next slides.
Thank you very much, Captain Abdullah. Thank you for the detailed explanation. I wanted to say to our audience that this is not a training sessions on the LLMC or any other convention, but rather an update on what is going on behind the scenes. But now, thank you so much, Captain Abdullah, for a detailed explanation how it works. So as as the captain was already saying, I'm very excited as well that we have ratified the LLMC 1996 convention, that we are going to ratify the Bunker Convention, hopefully the Nairobi Convention, that's the wreck removal convention, and the HNS Convention, hazardous and noxious substances, will follow. For any non-lawyer now in the attendee room, you will be slightly confused with all these keywords. What do all of them have in common? They have been drafted and approved and agreed by the IMO, and they are composing a strict liability and compensation regime. So literally, it is a kind of a quid pro quo. You, ship owner, you will be held strictly liable. We do not need to take you to court. We do not have an unclear outcome. We do need to take you to court, but we do not need to have a very unclear outcome, a very long delayed procedures. We have a strict liability independent of your fault. In return, as the quid pro quo, you are allowed to limit your liability, as Captain Abdullah explained, very detailed. What I find extremely important in the LLMC convention, you as a claimant, you can direct your claim directly against the insurance company. What is hugely important, especially maybe in our part of the world where the ship owner tends to disappear. The ship owner is gone, he's somewhere, we don't know where he is. It turns out to be some SPV company somewhere in the Bahamas. Nobody's clear who's actually behind it. So even if we eventually obtain a successful judgment, the enforcement is something very different. So having the right to go directly against the insurer will bring a lot of clarity. Now, what you see on the slide in front of you, I would like to speak about the practical aspect. As you all now know me, for me, it's okay. It's a great step forward. We have ratified the LLMC protocol, and now what? How will it work? How does it make a difference in you and my life? Just to come again, any vessel above 300 tons, for any of these vessels, any claims against these vessels or the respective cargo on the vessel, you can limit your claim. If you have a claim for loss of life of imminent injury, damage to property, salvage and wreck removal, both for ship and for the cargo, what can be very dramatic if we have containers floating around in waterways causing a dangerous hazard or consequential loss. Now, the interesting part is how do you actually do that in the real world and in the UAE? So at the moment, we say the LLMC is clearly stating you do not need to establish a limitation fund. You see the first point, approach towards the constitution of limitation funds. You as a defendant, you as ship owner, you can limit your liability, but by providing the funds, by providing the amount to court in certain jurisdictions. In other jurisdictions, you have to establish a fund. How do we establish the fund? This is not a detailed lecture. This is just a bit of an idea how it will be going. What the LLMC protocol made very clear, this is a general liability regime. How the national laws will enforce it, it's something very different. And it's given, the right is given to the national laws to enforce on certain points, to opt in, to opt out, so to literally make the liability convention a part of your national law. With regards to the LLMC, countries have adopted very different systems. Some countries allow for the limitation without establishing a fund. Others make it a requirement. Certain countries allow the person liable to establish the fund immediately without the claimant being able to argue that he or she can or cannot do so. In other countries, the approval of the court is required prior to the establishment of the fund. How are we doing it in the UAE? I don't know. Honestly, I don't know yet because it's not clear yet. We need to have a local law to be clear around how we want to do it. What should also be regulated is the priority of claims. Personally, I would prefer, obviously, loss or life should always be first and is separated under the convention. And when it comes to damage of cargo, I personally would prefer if ports get a priority of their claims. If Captain Tama is listening in right now, he will be very happy to hear that. I'm sure of that. Now, could we Hani, could you do me a favor and move to the next slide? So the current, now comes the interesting part. The current practical approach towards the LLMC, there's literally none. I'm sorry, but I have to say that. We have ratified the existing convention, as Captain Abdullah explained. The ratification now, it's not new. It's just a protocol of the higher limits. We have ratified the existing convention. However, as we haven't got a national law to detail the procedures, how to establish, and more important for me, even how to administer the fund. At the moment, it works different in every court. As you know, we have 7 different emirates. We have different Supreme Courts. At the moment, it is dependent on the judge. The judge might apply Sharia law, definitely when he's regulating compensation for death or injury. You can see 138 of the UAE maritime law. When it comes to limiting your claim, again, the UAE maritime law has a provision in Article 141. However, the maritime law has also a number, I think it's Article 8, where it clearly says international treaties supersede the maritime law. So the LLMC should find applications. We have an interesting case, but it's ongoing. It's not final yet, where the Supreme Court has looked into applying the LLMC convention and has moved the current case back to the predecessing court to decide. But again, at the moment, there is literally no local law. So there is, at the moment, the question is, can you limit your liability under the LLMC with much higher amounts than under the current UAE maritime law, I have to say. The other question will be, can you establish a fund? Now, why would I find the fund so important? Let me just see. I think we need to come to the next. No, I can still say it on this slide here. Yes. So before we come to the fund, one comment maybe for the lawyers between you is the forum shopping. If I have a situation at hand where I think I can establish a fund, I can establish the limitation of our client's liability, I would immediately commence forum shopping. What does it mean? I would look in which jurisdiction am I able to limit my liability and where is it the lowest. Where currently we had the 1976 with much lower limits as Captain Abdullah applied, it would be a preferred jurisdiction for me because we have lower limits. On that point, lawyers would start going on cross-border jurisdiction and working out, could I go to a country where we have no links to? I haven't been sued. Obviously, the claimant would want to sue me in the jurisdictions where I have my asset and where I cannot limit my liability. I now, on the other hand, I would like to start going somewhere where I can limit my liability and I can do it on a much lower level. The question is, which country would allow for me to go establish my limitation fund without having a claimant? For example, the UAE courts would say, where there's no claimant, there's no defendant. There are no preemptive jurisdictional cases here. The court system here works. You have to be sued in order to defend yourself. You cannot have a preemptive application to say, I want to establish the fund here because I assume I might be sued. But that is the point on the side on forum shopping. On this slide, actually, maybe one point what I would like to mention as well, we have a slight problem at the moment where I do not know yet how it will be tackled by the courts. We have ratified the 1996 protocol with a much higher limits. However, we have not denounced the LLMC 1976. So strictly speaking, currently, we have 2 different limitation regimes. How that is working in practice, again, as a lawyer, I should say it depends. But honestly, I don't know. I'm unclear about it. I would like to urge the government to denounce the LLMC 1976 to be very clear about the limitation regime we are applying. But that is on a different point. So now let us look. As I said, at the moment, we haven't got the national law, but I would like to speak about it. What you might wonder now, why am I babbling on and on about the limitation fund? I find the limitation fund extremely important. What is the limitation fund? I am the ship owner. There's a claim against me. I had an oil spill, the vessel sank. People have died, different cases. Now let's see, I see under the LLMC, I can limit my liability to $10 million. I know the claims against me will be at least $50 million. Who comes where? Who gets what? If you put the money in the fund, the ship owner puts the money in the fund, or the funds in the fund, then it's up to the fund, to the administrator of the fund, to decide who will get which proportion of that claim. But now, I would wait for the question now to come, and in a one-on-one meeting, most likely the question would come, what is if there's only one claimant? How do you know there's only one? If there's only one claimant who takes me to court, I put the money in court, the judge decides that claim, what is if next year another claimant is coming and no limitation fund has been established? How will that work out? That is something where I think it would become very, very problematic. Now to say, will it be possible to establish a limitation fund in the UAE currently? Currently, there are no procedures, as I said already. Currently, it is simply not possible because the court would not know how to do it. The court would, I think in one case, it happened that the court asked the FTA, and the FTA, rightly so, came back and said it cannot be because there is no law at the moment where you can base the limitation fund on. So that is something that needs to be discussed with the government to set the law in practice. Another point where I find it very important, the moment me as a ship owner, I establish a fund, I can seek the release of my vessel. So again, you claimant, you had a damage, what you do first thing, you have a maritime lien, you arrest my vessel. I can provide the security to have it released, or I provide the security within the fund. The fund will be security enough to have the vessel released under the LLMC. But again, we would need to clarify it under local law. Who is the right body? The last point here. The FMA, in my opinion, the FMA is a regulatory authority under the UAE maritime law. The FMA would need to put forward a draft to the government to say, we think the procedures and the tools for a fund should be provided so it can be properly done. A very important question for me on that point would be, who will be the administrator? I have the permission now to establish the fund. Who will administrate it? The courts, who are so incredibly busy, all of you non-practitioners here, each judge is in the first or in the second instance, in the first even more, in the Court of Appeal, I think the judges are looking at around 300 cases a year. That is more than one case per day, per working day. Now, how would a judge have the time to be the administrator? The administrator has an incredibly important role. The administrator is looking at the claims. Is the claim valid? Is the amount claimed? They will defend. They will defend if they think the claim is not valid. They have to do the apportionment like an insolvency administrator, literally. Can a judge do it? Looking at the current time constraints, I absolutely doubt it. Will the judge pass it on to a court expert? Personally, I wouldn't be happy about it because, again, a court expert is not an experienced administrator in these cases. Would the government say we will pass it on to insolvency administrators or to lawyers? I would prefer that to somebody experienced. If the government would go that far, honestly, I don't know. I don't know many jurisdictions where the administrator is not the court, but it is somebody very specialized in that area. How it will be done remains to be seen. If it will be done remains to be seen. Hani, could I have the next slide, please? Now it comes to the most important question for many of you sitting there. What makes a whole thing tick? Money. So again, I want to constitute a limitation fund. How can I do it? Only ever by providing the amount. Now, what is the LLMC is saying? You provide it either by the cash or by an acceptable guarantee. Interestingly enough, the guarantee has to be acceptable in our jurisdiction. So we are looking for, of course, what is currently acceptable in our jurisdiction. The court likes cash, I have to say. The court prefers cash. The court prefers cash or a manager check. What is as good as cash? A regular check, I would say no. I doubt it very much. I think the court would insist on a manager check, but I'm happy if somebody's proving me wrong. Now, the interesting question. I mean, now every ship owner listening in here should sit there and say, oh, the last thing you want to have in the current situation is having such a hink into your cash flow, having to put this whole money into court and you don't know for how long. So it would be much better, of course, you're all waiting for me to say it, is the letter of undertaking from a club. But let's go one back to point number 3, a bank guarantee. A bank guarantee, for me, it's much cheaper. I can negotiate with my bank. I save my cash flow. What in the current COVID crisis is absolutely fundamental. Now, again, a bank guarantee by the local ship owner buys here with a local bank here. I do see that. I do think the courts would allow it. But now, of course, you ship owner, again, I was waiting for, in my mind, I see certain ship owners raising their hand, say, hello, hello, hello. Why would I need to provide the bank guarantee? I want my club to provide the bank guarantee. It took me long and hard to negotiate with them to actually do it. And certain clubs are willing to do so. Will the court accept a bank guarantee from a club? I doubt that. No. No, even more. I don't doubt that. I think no. Why? The club has definitely a much higher security than any local ship owner here, or most of the local ship owners. But the club hasn't got a bank, a local bank here. The club has a bank in their country. That would be most likely in England. However, if the club is now saying, I provide a bank guarantee by my club correspondent who's based here in the UAE with a local bank, that is something else. Again, on that point, I would assume it is acceptable enough, and I would assume that will work out. The most interesting question for us lawyers now, of course, number 4, will a letter of undertaking be accepted? Letter of undertaking, I assume all of you know what it is. It's for us the fastest instrument. We have a collision instead of arresting both vessels, instead of having this case heard for years. There's an exchange of letter of undertakings between the clubs. For me, a letter of undertaking is better than a bank guarantee, at least as good as a bank guarantee. Security is provided, trade can continue. It's safe, it's fast, it's cheap. It's much cheaper than a bank guarantee, obviously. But, and I know you were all waiting for my but, at the moment, courts do not accept a letter of undertaking, what is very frustrating for us in case of arrests, because again, as I said, we have to provide the amount in cash. That would be something, once the law would be changed, the law would need to be changed. You cannot blame the courts on this point, because at the moment there's no provision for the courts to actually accept a letter of undertaking. It's an instrument you cannot tackle like a bank guarantee. Once the law has a clear statement to say a letter of undertaking will be accepted by courts, in my opinion, for an arrest, in my opinion, it should be good enough to constitute a limitation fund as well. But it would need to be clearly stated in the law. If you just say a guarantee or a cash, there was a case law in England a few years back where an LOU is a very accepted instrument, but the court said, no, it does not say it clearly in the procedural rules that it's accepted. So on that point, we would need to state that very clearly. I think I have come already to the end of my slides. Sorry, I should know that. I'm not having to look at it. On that point, yes, I think that is the end of our explanation on the LLMC and the limitation funds. Any question you are having, you see up there, you see these little question marks. If you click on it, there is a live Q&A. Drop your question. Just drop your question, ask the question there. We can pick it up and answer it at the Q&A session after. I will pass back to Captain Abdullah, who I hope I didn't take too much of your time, Captain, to explain the extremely important bunker convention, where I'm very excited that we are going to ratify it. Thank you so much.
Thank you, Jasmine. And yeah, the point you raised, in fact, it is under discussions here about denouncing the LLMC 1976. We are still discussing this internally, and a decision will be made. And yeah, we understand your point of view in this regard, that we should not have to redeem. And I believe many countries has denounced LLMC 1976 once they acceded or ratified 1996 protocol. So this is under discussion internally, and you will hear something hopefully soon. Now we move to another important convention which has been acceded by the UAE recently. As we mentioned earlier, that we are at the stage of depositing the instrument of accession to the IMO, and it will be entering into force 3 months after depositing the instrument. Bunker Convention is one of the important conventions, and which has taken seriously by many countries. As we can see, the number of contracting states for this convention is 100 right now, representing 95% of the world tonnage, and the convention has entered into force in 2008. The convention was adopted to ensure that adequate, prompt, and effective compensation is available to persons who suffer damage caused by the spill of oil when carried as a fuel, as bunker.
Next slide.
Yeah. So if we go to the next slide. One should remember, oil tankers are not the only vessel that cause pollution damage at sea. Most of the people they think that oil pollution means disconnected to tankers. No, in fact, there have been numerous heavy fuel oil spills from non-tankers as a result of escape or discharge of bunker oil from them. Nevertheless, although there was numerous cases of bunker escape and spill, there was a legislation gap in dealing with such spills from the bunker. So while the pollution from tankers has been governed by the CLC 1969 and then by the Protocol of 1992, CLC 1992, there was a legal gap related to oil pollution from ships other than tankers coming from bunker fuel. So the Bunker Convention has filled this gap. In the pollution legislation, so that any substance which may escape from the ship now are covered by the liability and compensation regime under the Bunker Convention. If you will read the Bunker Convention, you will notice that there are 3 main features which is similar to the CLC and the fund conventions. One of them, as we can see from the slide in the front of us, there is a strict liability and very limited exceptions from liability, which means there is no need to prove responsibility for the pollution, only that the pollution originated from the vessel. So this is one of the similarity we have. Secondly, there is a compulsory requirement for insurance. Any vessel which is over 1,000 gross tonnage must have an insurance coverage for the bunker pollution. And hence, if there is insurance coverage, you have the right for direct actions against the insurer for claims from third party for cleanup expense and other losses. And the third similarity, we have the limitation of liability. So we have the 3 components which has similarity with the CLC and the fund convention. As will can be noticed from the convention, they used a broad definition when it comes to the definition of owner. So they include the registered owner, bareboat charter, and manager, which is different than the CLC. For the limitation liability on the bunker convention, it will be noticed as well that the bunker convention is heavily dependent on the LLMC 1976 and 1996, and this is where we can see the connection between the two conventions. And when we acceded the 1996, it was normally to ratify the convention because they are connected. They are connected when it is coming to the limitation of liability, as we mentioned that the bunker convention is heavily dependent on the LLMC convention. So in the bunker convention, I believe it is in Article 6 of the convention, the owner of the vessel is entitled to limit his liability in accordance with the convention of limitation limitation of liability for maritime claims. The bunker oil, as defined in the bunker convention, is any hydrocarbon mineral oil. So it is include lubricant oil by bunker oil. So any oil used or intended to be used for the operation or propulsion of the ship, and any residuals of such oil is considered as bunker oil. It is unlike the definition of the oil in the CLC, which is restricted the definition of the oil to be the persistent oil. So in the bunker, it is not limited to the persistent oil and may include lighter fuels such as marine diesel and lubricant oils. If we go to the next slide. Yeah. So the pollution damage. The pollution damage has been defined in the convention as any loss or damage caused outside the ship by the contamination of the bunker or by the fuel from the ship. As well, the pollution damage means the cost of preventive measures and further loss or damage caused by the preventive measures. So we have a definition for pollution damage, which include as well the cost of preventive measures taken in case if there was a spill and the state taken preventive measure, and in this case the convention is considering the preventive measure as part of the pollution damage. If we move to the next slide, Mu'in. The question raised why the convention is important. There's many conventions we didn't ratify yet. It is in the pipeline. The question raised why we started, for example, with this convention and we gave it a priority comparing to the other conventions. It should be taken into consideration that half of the total number of pollution claims worldwide are result from bunker spill. In addition, as you can see from the photo, can indicate to you as well, the bunker oil spill, because of their physical properties, are more difficult to clean up, making it most costly to clean than crude oil. The bunker oil, as it is known, is thick and does not evaporate or disperse easily. And usually manual cleaning is often the only options. So most of the cases we saw even here in the coast of the UAE, we end up with manual cleaning for the heavy fuel oil. And even the disposal of the oil later on is a problem and can be difficult as well and expensive as the cleanup operations. I think we believe that by ratifying these conventions, it will be in favor of the ship owner and the SISDA. It will limit their liability, it will sustain their business, and it will encourage them to develop and continue their operations. For us, as a benefit, as a maritime administrations, it will enhance the confidence in the UAE maritime sector. It will fulfill our international maritime requirements and standard, and it will furnish the legal framework for compensation. So we have covered the oil tankers. Now we have a regime to cover as well the pollution coming from other pollutions from ships other than tankers. If we go to the next slides, Mu'in. I'm not sure if you remember this accident. This is Wakasho, the bulk carrier which ran aground last year. So despite the fact that most of bunkers still being operational spills, most of them they are operational spills, rather than accident or casualty. However, accident occurred and happened, and has a devastating result, as we have seen in Wakasho, the picture in front of us. The accident happened last year. I believe it was in July 2020, and there was escape of 1,000 tons of fuel oil, which has hit the Mauritius coast. Fortunately, there was 3,000 tons of fuel. The salvage company, they managed to remove it before the ship broke in two. The ship broke in two a month later after the grounding. So the successful removal of the 3,000 tons of fuel prevented further damage to the environment. So this one was the major accident of oil pollution caused by bulk carrier Wakasho last year, and the pollution has severe damage to the environment of the Mauritius territorial water and coast. If we go to the next slide, Mu'in. Yeah. Unfortunately, at the time of the incident, Mauritius has ratified LLMC 1976, not the protocol. So under the LLMC 1976, the limit for third-party claims, which include the cost and preventive measure and cleanup following the grounding, would be around 18 million SDR, special drawing unit. So 18 million with the LLMC 1976. Why? If it was under 1996 protocol, the limitation fund would have been over 43 million SDR. So this is showing the big change on the amount of limitations by ratifying the 1996. So this is the reason which has encouraged us to move fast and to exceed the 1996 protocol to raise the limit amount. If we go to the next page, Mu'in. So the question which is raised after this accident, what if the same happened in the UAE water? I mean, we took actions. We raised this question internally, and based on that questions, as I mentioned, we moved fast to exceed the 1996 to avoid what happened in Mauritius, that their claim can be limited to a cap of 18 million SDR, while if they have exceeded the 1996 protocol, the limitations could have been higher, and then the compensation will be higher. I think the cost of cleaning the Mauritius coast will be more than 18 million SDR. I think it was a lesson for all states to ensure that LLMC 1996 is ratified before they end up with a case similar to what happened in Mauritius. So if we move to the next slide, Mu'in. So I leave this one to Jasmine. Jasmine, the mic to you to shed light on how UAE courts currently deciding on oil spill matters.
Thank you very much, Captain. And again, thank you for the presentation, for the explanation. I hope the attendees are still very interested. I don't see much on the conversation. I try to keep following what is happening there. Anyway, just the last point. I know you all want to go back to your desks. How do we deal currently with the situation? We have an environmental law, and currently the UAE courts will apply this federal law. What I have put up there on the slide on the bunker oil spill, we have this environmental law on an oil pollution. Again, I think the courts would actually apply the CLC in addition to the environmental law. So as I said, for us, now you might understand why I'm so excited, because in the current situation, we had hardly any proper system to deal with a bunker oil spill. Any of you who has ever seen it, or the Wakashiu was the best example now how dreadful it can be. We as a country, we live from tourism, we live from our beaches, we live from our environment. It's very important for us. Now just picture again after COVID, our hotels have just recovered and something like this would happen. That would be literally the end to our tourism and a very important income for the country. So on that point, to say we have a proper protection in place, companies, anybody else could go out of their way to help because they know they will be reimbursed. I think that is the main important message. One other message, I think what the technical question would be asked by any agent right now is, do I now need to have the CLC certificate on board, what most of the ships have already? Do I also need to have the bunker CLC certificate on board? Well, I think, again, I'm sure Captain Abdullah wants to say something. I think yes, I think it needs to mean the ships need to have 2 certificates on board. What is not any big problem, because your flag state will easily provide that. So on that point, there's literally one email. Most of the flag states have an online platform where you can apply for it, send the documents and get it. So that's not a big problem on that side. I'm referring back to Captain Abdullah. Thank you so much.
Yeah, thank you, Jasmine. Yeah, on the question raised, will tankers will be required to have the bunker convention certificate beside the CLC? As you mentioned, yes, they will be required. It will be issued by the administrations, by our authority. Once we have the blue card by the ship owners, the certificate will be issued as the procedure right now for the CLC. Currently, the UAE flagships, because we didn't ratify the convention, they are getting their bunker CLC from other states. But once the convention will enter into force, the bunker CLC will be issued by the Maritime Administration, by the FMA. Yeah, so I think this is the questions we have. I'm not sure, Mu'in, the floor to you, Mu'in, the mic to you, Mu'in, if you have any other questions raised by the attendee.
Actually, I don't have further questions coming to us related to this this important subject about the ratification of the convention and the protocol. However, if there is no other further question, I would like to move to the last part of our webinar, which is the upcoming ratification for United Arab Emirates. If you allow me, Captain Abdullah, to start this session, if there is no question, Jasmine. More other questions or no?
Sorry, I was just wondering, I do see a number of questions here, published questions on the live event. Moin, if you go on these question marks up, you see the live event Q&A. I think all attendees can see them. One good question, can national law increase or decrease the limits of liability? Again, a lawyer would like to say it depends. Yes, it can be done. We can, yes, in brackets, in limits, it can be done. We can definitely say we can increase something that is close to my heart. It is possible under the convention to opt out of these limits for wreck removal, for salvage and wreck removal. And I would strongly urge the government to look into that, because any experience with wreck removal costs, they're exceeding these limitations. Again, who has been here from the beginning, I used to work in law firms in England and Hamburg where we represented the respective governments. Now, I know I sound very old, but that was more than 20 years ago. We had to rely on the 76 limits. They were even lower, but wreck removal is a very expensive matter, even in our shallow waters here. And the government having to stick with these limits and the government in the end having to pay for it, it's not right. So on that point, I would like for the government to opt out of the specific area and say, we do not allow you ship owner, your insurance company, in the case of a wreck removal, to limit your liability, but you will be fully liable on that point. What we can do for smaller vessels below 300 GT, we can add this to the convention. We can literally say we have quite a large fleet here of smaller vessels. We would like to want them included. That can be done as well. I see another question here. Was any limitation fund established in the UAE? Dear listener, I dealt with that already. No, because at the moment it's simply not possible. We haven't got the procedure law. I wonder if I'm seeing other questions here. I'm just trying to get to them. Sheet.
If you allow me, there is one question I think remaining in our loop here. It's about the. Let me check. When does the owner lose the right of limit its liability? Did we talk about that?
I don't think so. I don't think so. But it's sorry, I'm still on. I don't think so, but it's a good question. It's and we don't need to establish national law for that. It's dealt with under the convention. The convention is saying in Article 4, prove me wrong, Article 4 or 5, where it's saying very clearly if the person who can limit their liability is reckless or is using a wrongful act, it's literally has caused the damage by willful misconduct, then they will not be able to limit their liability. So it's not easy. It's a strict liability system. It's strict limitation liability system. So it's not so easy for a claimant to say, you ship owner, you are not allowed to limit your liability. You should be fully liable. You would need to prove, you claimant would need to prove the willful misconduct. I think that's it from my side here. I'm just looking at the questions. The other questions I see here, I think we dealt with them.
Jasmine, if you allow me, what about some issue about unseaworthiness of the vessel? If the ship owner will know, or his managing company know about the condition of unseaworthy of the vessel, and he hide this nature of this type of vessels, or about the truth about his unseaworthy, will we also lose the right of to limit his?
I think it's a very good question, because there's another problem. If a vessel is unseaworthy, you would lose insurance cover. So again, you would lose insurance cover. The blue card would cease. Me as a claimant, if I'm the claimant on this point, I would have a claim against the insurance company, but I wouldn't anymore, because the insurance company would pull out and say this vessel is unseaworthy. You do not deserve to have cover, would be pulled literally. And for me, that would be willful. Interesting question if that would be considered, because willful misconduct, in my opinion, has to be for causing of the Article 4 of the LLMC is saying a person liable to not limited if it's proved that the loss resulted from his personal act or omission committed with the intent to cause such loss. If you have an unseaworthy vessel and you're just hiding it, doesn't mean you have the intent to cause the loss that happened or does. I think that would be up to the courts to decide if it falls under. I think if you have an unseaworthy vessel and you know it, you're not turning a blind eye, you are knowing, that constitutes willful misconduct for me. That constitutes. So I would, on that time, I would argue you're not allowed to limit your liability. Back to you, Moin, on this point.
Okay, thank you, Jasmine. Thank you. I don't know if we have further questions coming from the audience or the attendees. Do you think that the establishment of national laboratory is needed? There's a question here. Do you think that that establishment of national laboratory is needed to prove the? What is it? I lost this. Again. There's Q&A again here.
I see that. Do you think that the establishment of national laboratories needed to prove the damage caused by a ship? I think I know what that attendee means, but that is not something what we would need to establish. We have that very much. We had oil spills and bunker fuel spills since I'm here, I think since the beginning of shipping. So on that point, we have fantastic laboratories, we have fantastic surveyors. This is, it can be found out literally immediately, the quality. And again, the damage caused by a ship, there we're coming back to the administrator. The administrator would have, of course, expert surveyor experts on site. And on that point, this is like any other collision where we have survey reports who establish the quantum. In any case, you always have two levels. You have the liability and the quantum. First one, you want to know, are you liable or not? Next step is, what is the amount you're liable? On that, we are relying on surveyors, and the surveyors in our country are great. So there is nothing what we don't have, what we would need to establish.
Okay, if you allow me, Captain Abdullah, just for the explanation, you know, usually the pollution coming from cargo of the ships, which is from tanker, it's easy to prove because usually it's a huge quantity and it's clear for many surveillance or control systems, including satellite image, satellite. It's easy to prove. But from bunker, sometimes if it's a small amount, here we need a laboratory, of course. Also, we need the kind of investigation to do that. Also, to make about bunker delivery notes for the ships to compare it. There's a lot of steps of investigation goes to prove that this vessel caused this kind of pollution coming from bunker side. This is very important also because when it's considered unknown source of pollution, sometimes it will need more investigation. And within the Maritime Administration headed by Captain Abdullah, we have all resources and good investigators to do that in cooperation with some important entities or authorities where they have many resources. I can say Masdar, they have also satellite image they can provide. It's not an easy to escape from any kind of causing pollution coming from bunker. There's another question, Captain Abdullah and Jasmine. Do you think that the IMO should come up with a claim manual related to bunkers 2001 without interfering with the national court jurisdiction? I think it's a good question. Of course, IMO, Captain Abdullah, of course, IMO, they have a lot of resolutions coming, resolution mandatory, take mandatory status, explaining a lot of guidelines coming from IMO. Even we can talk every year coming for not only this convention, for many conventions. So they going, it's a living document. It's the issue a living document. A lot of circulars, a lot of guidelines to cover all gaps coming under any conventions and to remove any ambiguity about how we implement and enforce any IMO instrument. So this is what can I say about that. Captain Abdullah, maybe you have further.
Well, I didn't see the question, Mu'in, but
do you think that IMO should come up with a claim manual related to bunker 2001 without interfering with the national court jurisdiction?
Well, the IMO has nothing to do with the jurisdiction of the state or the court of the state, yeah. So I mean, if there is any conventions will come from the IMO after being adopted, but the IMO has nothing to do with the jurisdiction of states itself. But as you mentioned, yeah, they are coming with circular and some recommendation from time to another, or if there is any requirements, it will be adapted within the MARPOL conventions related to the bunkering fuel.
Come. Okay. There's a question also. The United Arab Emirates and Gulf waters have several offshore vessels which are less than 1,000 gross tonnage. Are any regulation applied for these vessels regarding pollution? I think it's a broad question, but of course there is national ministerial decision about dealing with all kinds of oil pollution or kind of pollution, even from air pollution. Recently, the ministry issued a circular or a ministerial decision about the Annex 6 implementation of MARPOL to deal with all kinds of pollution coming from air pollution from ships. In addition to MARPOL Annex 1, 2, 3, 4, and 5, there is a big ministerial resolution decision. It's coming with, I think, 106 articles explaining what is national legislation to implement and enforce MARPOL convention with all its annexes from 1 to 5. And there is another ministerial decision dealing with the Annex 6 separately. So many things there.
I can add, Mu'in, as well. The convention apply as well for vessels less than 1,000 gross tonnage. The convention is still apply.
Yes.
But the 1,000 gross tonnage is a requirement to have the certificate. So the certificate is required for vessel over 1,000 gross tonnage, but the convention is still apply for vessel less than 1,000 gross tonnage.
Okay. There's one question: are the provision of the 1976 convention still applicable? This is a good question. Captain Abdullah, I think we had a discussion about with the legal department about, are we going to denounce the convention, previous convention about CLC, or still we have to keep it as a piece of legislation still valid in conformity or in parallel with the new protocol? There was,
I think we answered this one. I think we answered this one, Mu'in. We answered this one already. We mentioned that is under discussion internally. Yeah. So this is a discussion, but it's valid point raised by Jasmine, and we are looking at it.
Okay. I think we tackled with all. Was any limitation and establishment? Okay. Can national law increase or decrease limits? Well, did we answer that? Can national law increase or decrease the limits of liability?
Yes, Moana spoke about it already.
Yes, okay, sorry. So I think we finished this because I just now can see the screen about all the questions. Sorry to come back to some answer the questions. I think no further questions coming. If you allow me, Captain Abdullah and Jasmine, to go to the next part of the webinar. It's about the new ratification. What's coming in our screen?
Okay, Mu'in, we can, because I think we came to the end of the session, maybe you can shed light on the new convention and the pipelines. I don't think it is in the presentation, but you can shed light on our new plans or future plans for ratifying the conventions in 2021.
Yes, Captain Abdullah. Actually, as I have said about the ministry effort and the maritime administration to do, it's currently doing its all efforts to complete the state's accession to a set of important international instruments related to marine environmental protection, safety of life, So there's a lot of conventions coming. I can see maybe 2 or 3 now in our radar, on our screen, to complete the provision of the regulatory and technical frameworks for the safety of navigation, removal of navigation obstacles in the course of ships, and to preserve the marine environment, to protect the marine environment. So the first one is the Nairobi International Conventions on Removal of Wreck, done in 2007 and adopted in Kenya, and this is why the name is Nairobi in 2007. This is the convention. It's provides a legal basis for all member states who will be joining or be party of this convention to remove or have removed shipwreck that may have the potential to affect adversely the safety of lives, goods, and property at sea, as well as the marine environment. This is in general the aim of the convention. The second one is the International Convention on the Control of Harmful Anti-Fouling System on Ships. The convention was adopted on 5th October 2001 and will prohibit the use of harmful organic compounds in anti-fouling paints. This related to the paints of the ships, and will establish a mechanism to prevent the potential future use of other harmful substances in anti-fouling system. The convention entered into force on 17 September 2008. So this is the second one. The third one, now this almost, we did all transaction at the Maritime Administration. It's about the OPRC, which is the International Convention on Oil Pollution, Preparedness, Response and Cooperation. It's called OPRC. This convention has been forwarded to the Ministry of Foreign Affairs to make clearance to start the other procedure to ratify this convention in general. And just maybe I can say a few words about that. It's about the parties to international conventions on oil pollution preparedness, response and cooperation, OPRC, are required to establish a measures for dealing with pollution incidents, either nationally or in cooperation with other countries. Or ships are required to carry on shipboard oil pollution emergency plan, and operates offshore units under the jurisdiction of a party are also required to have oil pollution emergency plans or similar arrangements, which must be coordinated with national system. So this is in general what's about the system, about the convention.
Thank you, Mu'in. Thank you. Appreciate that. Thank you. Okay. I think we came at the end of this session, so this webinar. I would like to thank Mu'in for being the moderator. I would like to thank Jasmine and her team at Fish & Co. As I said, the Fish & Co, they are very supportive to the Federal Maritime Authorities events. So we are very thankful to Jasmine and your team. Thank you for organizing with our team this event. And thank you for the attendee. And I hope we'll come frequently with such webinars. So as we mentioned earlier, to keep the maritime sector and the stakeholder up to date with the latest progress and up to date with the latest news from the Federal Maritime Authority. Engineer Mu'in, if you want to end the session, the webinar.
Thank you, Captain Abdullah. Just a small announcement that there is a link to do your registration for all distinguished participants in order to issue a tender certificate for each participant. So this is the last announcement. This will complete our meeting, Captain Abdullah, today and the webinar, and we would like to thank you, your speakers and all participants to this webinar. Thank you very much, and we hope we meet you in other valuable also webinar or forum. Thank you very much.
Thank you very much. Thank you very much, FMA and attendees. Have a good day, and any queries, please send us emails. We can explain in more detail. Thank you so much, Captain. Thanks so much, Mu'in. This session is ended now. Thank you.
Thank you.